Hello, everybody. Sorry we're running a little bit late. I'm delighted to welcome you to the 2023 Scalia Lecture called Beyond Textualism. I'm eagerly waiting to hear what that means. It's by Will Baude, the Professor of Law and Faculty Director of the Constitutional Law Institute at the University of Chicago Law School. I'd like to start by extending a warm welcome to Mrs. Scalia and other members of the Scalia family who are joining us here today. So please. Now let me just say a few words about the lecture, its namesake, and the person who's here to deliver it today. The Scalia Lecture was established at Harvard Law School in 2013 by an anonymous donor to promote and advance our understanding of the founding principles and core doctrines of the U.S. Constitution. Speakers are drawn from the fields of political science, history, philosophy, law, government, religion, and related disciplines. The person chosen to be the Scalia Lecturer must be a scholar or figure of high distinction who, through their work, research, writings, and teaching, elucidates the principles of the American founding. It's personally very meaningful for me to be able to convene the Scalia Lecture. As Justice Scalia's law clerk, I got to know him very well. He loved the law, he loved ideas, and perhaps above all, he loved to mix it up. That's how he learned, and that's how he encouraged others to learn. He was also a generous friend to this law school, which is his alma mater. He returned here often to judge moot courts, to meet with our students, to give lectures, and even to teach a class or two. What struck me was that whenever he came here, he would engage in spirited, candid, direct exchanges with student, staff, and faculty about ideas, doctrines, or decisions. He provoked lively discussions while he was here, and often for some time after. And as my predecessor, Martha Minow, noted when Justice Scalia passed away, he always brought a terrific sense of humor and great personal warmth to our community during those visits. We are delighted to host the Scalia Lecture today. Okay, so on to our speaker. Professor Will Baude teaches federal courts, constitutional law, and elements of the law at the University of Chicago. He's one of the leading scholars of constitutional law today. His writing addresses important topics in the Constitution, including the meaning of the necessary and proper clause, the privileges or immunities clause, Article 3, really an array of subjects far too broad to enumerate. And he is one of the leading theorists of constitutional interpretation, writing in the originalist tradition, and finding really lots of interesting and sometimes unexpected things in his research. Professor Baude is co-editor of the casebook, The Constitution of the United States, and has recently joined Hart and Wexler's The Federal Courts and the Federal System, and is thus my newest co-author. He is also a founding member of the Academic Freedom Alliance and a member of the American Law Institute. He recently served on the Presidential Commission on the Supreme Court of the United States. As you can see, he's a pretty busy person, and we're delighted to have him here. So without further delay, it is my pleasure to introduce Professor William Baude.
Thank you, Dean Manning, for that introduction and for the invitation to be here. I will confess, I believe I have watched every Scalia lecture available on YouTube, and for many years have thought that one day, maybe, if I played my cards right, I could be here delivering this. I'm a little surprised to find that the cards came up so soon, but I'm honored and thrilled to be here. All right. Last fall, I was at another law school, visiting with a friend, a co-author actually. And so, of course, we started talking about legal interpretation. I went into his office, he shut the door, and then the first thing he asked me was, do you think textualism has sort of played itself out? This lecture is about the answer to that question. All right, let's start with what the lecture is not about. The reductio ad Bostock. You may have heard this argument, made especially by conservatives in the past couple of years, and it goes something like this. Textualism brought us Bostock. That's the interpretation of Title VII to apply to discrimination on the basis of sexual orientation. Bostock, the argument goes, is bad. Therefore, textualism is bad. I have very little patience for this argument, so I'm going to dispose of it very quickly. If your complaint about a method of interpretation is that some judges failed to use that method of interpretation correctly, you are not complaining about that method of interpretation. You are complaining about some judges. And if your complaint about a method of interpretation is that even properly applied, it led to a result you dislike in a particular case, you are thinking about things in the wrong order. That is not how law works. All right, enough about Bostock. I am talking about a much bigger question. Is textualism missing something important? Can we answer that question yes, without apostasy? Can we answer that question yes, without giving up on all of the useful and valid things that textualism helped us see? Now, I think the answer is yes, but let's start by saying that in a sense, textualism has won, and we have Justice Scalia to thank for that. The kinds of open and notorious anti-textualist opinions that made Justice Scalia's approach seem so necessary when he was forcefully advocating for it, a lot of them are now almost unthinkable today. You can pick your favorite examples. I have many here, which I'm going to abbreviate to make sure we get to the rest of this lecture. Tennessee Valley Authority versus Hill and its 20 pages of unnecessary legislative history to make the obvious point of what the statute said. The famously mocked line in Citizens to Preserve Overton Park versus Volpe about the ambiguity of the legislative history requiring us to eventually turn to the text. Manel versus the Department of Social Services of the City of New York, INS versus Cardozo Fonseca, et cetera, et cetera, et cetera. A lot of these are chronicled in a famous article by Judge Patricia Wald. You can find a lot of them in Justice Scalia's writings. As your dean has chronicled, in many ways, the kind of purposivism that exists today is a new purposivism, which is not that different from a lot of the fundamental tenets of textualism that was there to dethrone purposivism. So these days, the core idea that the courts might just sort of not care what the text says at all, or take it as a vaguely interesting statement on a sort of policy question, a lot of that has gone by the boards. A lot of that we no longer see, and so we may forget how important the basic textualist insight was in recentering interpretation over the past 50 years around the things that really matter, the law. And the same thing is true in constitutional cases. So to take just one example, in the Supreme Court's currently pending case of Moore versus Harper, the so-called independent state legislature doctrine case, the court faces the question whether Article 1's declaration that, quote, the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. It faces the question whether the word legislature there means something, or whether the Constitution is really written the same way it would be as if it just said in each state, without any reference to the legislature thereof. And by the end of the Supreme Court's argument on that question, I won't predict what the court will say, I don't predict it'll be unanimous, but by the end of the Supreme Court's argument on that question last fall, there seemed to be common ground among everybody, from the justices to the advocates, that the phrase legislature does mean something, and the struggle was to figure out exactly how much it meant, how thick it was, what the court's role was in second-guessing the views of other people of what legislature meant. But there was common ground about the meaning of that phrase, even if many people don't particularly know why it's there, or don't particularly think it serves an important policy role. It's there, and it's a fundamental fact of our law. Justice Scalia is part of what got us to this place. Now, it's possible that to get us to this place, Justice Scalia sometimes made textualist claims that were a bit overbroad. For instance, he insisted, more or less, that you should never, ever use legislative history to give you any information about the text, when in fact, it probably is okay to use legislative history, so long as you're very careful and clear about how you're using it and what proposition you're using it to reflect. So, in general, the textualist revolution was correct and salutary. But I do start to think, not just for these reasons, that it's getting to be time to solve some problems where standard textualist teaching might lead us astray. If we think of textualism, or the phrase the plain text, as just mantras, prayers to ward off the demons of bad judging, we will not find salvation. We need to understand why textualism is right. And if we do, then it may mean that sometimes, in some cases, our analysis will have to move a little bit beyond the text. So what do I mean? The key insights of textualism are really two things: positivism and formalism. The insight is positivism in the sense that judges are supposed to follow external sources of law rather than treat their jurisdiction as necessarily committed to make decisions in their own discretion. This is the key insight of textualism, is that when it comes to the question, what does the statute mean, or what should we do in this case where the agency or somebody else's behavior is governed by statute, the key question they're supposed to be asking is, what did the law say they should do? What does something else say they should do? And the central place in which we find that law is in the words of the statutes that are enacted by legislatures. This is what makes textualism, the argument for textualism, as opposed to policymaking. The argument for text over policy, positivism, in the sense that some sort of law comes from outside the judge, and it's the judge's job not to decide what is the best thing, all things considered, or what would make our legal order better rather than worse, all things considered, but to ask, what has somebody else decided about those things? What does the law require us to do, external to my own views of the law? The other key insight of textualism is formalism. Formalism in the sense that it requires recognition that the rule does not always match the reasons for the rule. That is, that rules and their reasons sometimes, either run beyond their reasons, the rule can be overbroad compared to the reasons for enacting it, and sometimes are underbroad, that the rule can not quite do all the things that you might want to do given the reasons for enacting the rule. Textualism is the recognition that when the judge enforces the law, the answer to those questions, that might sometimes be different from what the people who enacted the law would have wanted had they thought about the situation. This is the argument for textualism as opposed to intentionalism. The reason to follow text rather than the imagined or even sometimes known intent of the people who enacted the law. Formalism. The recognition that judges, when they're enforcing the rule that comes from outside themselves, might have to enforce a rule that isn't exactly the same as the reasons for the rule. These two things together, textualism reflects a basic insight central to the structure of our government and central to the fabric of our law as it has evolved in our legal system, that the job of an interpreter, let's call her a judge, is usually to enforce rules that have been made someplace else, not to make the rules herself, and not to imagine decisions that were actually never made by anybody. Those insights are the reasons for textualism, but those insights don't necessarily stop at textualism. So if we are going to continue to honor the basic structure of our government and of our own legal order, we are sometimes going to need to think more deeply about these jurisprudential insights that underlie textualism. The problem is that the text itself, even the text supplemented by something like the original meaning of the text, is incomplete. It gives incomplete or misleading answers to important questions about the law, and so it needs to be supplemented with attention to our entire legal framework. Because our legal system relies not just on written texts, but also on unwritten law. We need to supplement textualism with this unwritten law that governs both interpretation and background principles against which interpretation takes place. All right, what do I mean by this? Let's start with some simple examples. One stock example I like to give are immunity doctrines, such as qualified or sovereign immunity that bar claims against officials and governments for federal, statutory, or constitutional claims. In the main, these doctrines are unwritten, common law principles of jurisdiction and liability that say that even if the federal courts have jurisdiction under Article 3, even if Congress has created a cause of action in 42 U.S.C. Section 1983, even then, sometimes unwritten law operates to stop the claim from going forward. You see this in countless cases about qualified immunity, where the court will say, yes, we have by the text jurisdiction, we have by the Constitution jurisdiction, we have a constitutional rule, but even so, is there some unwritten principle that says we're not supposed to hold the whole legislature liable for having enacted an unconstitutional statute? That says, near and dear to the hearts of the judges, of course, that the fact that a judge ruled erroneously and reversed on appeal does not necessarily mean they owe damages for whatever consequences inured to their incorrect ruling. More controversially, I think more questionably, that various officials in charge of enforcing the law might not be liable for their own mistakes based on the doctrine of qualified immunity. Same thing we see in sovereign immunity. While the 11th Amendment makes reference to one form of sovereign immunity that operates as a bar on subject matter jurisdiction, the Supreme Court's cases mostly make reference to a common law immunity that exists in many more cases than are reflected in the text of the Constitution, that is older than the text of the Constitution, that was explicitly promised to skeptics of the Constitution at the ratification conventions in Virginia, New York, and elsewhere, and the court has recognized as a part of unwritten common law, without which one can't understand even the terms of the 11th Amendment or other aspects of federal jurisdiction. This is not just about the kind of stuff we do in Fed courts and we'll talk about in Hart and Wexler. It's true of the canons of construction more generally. So just last term, Justice Kagan, at oral argument in Isleta del Sur, Pueblo versus Texas, raised a lot of eyebrows with a very important sort of textualist salvo. She said to one of the arguing attorneys that she wanted to ask him about an interesting question that I've been thinking about a good deal about, what these substantive canons of interpretation are, and when they exist and when they don't exist. They're just all over the place, of course. And then she starts to recite various aspects of the so-called substantive canons. In that case, it was the Indian canon, which might actually be 3 different canons about the interpretation of statutes dealing with Indian tribes. But then she said, next week, we're going to be thinking about the supposed major question canons. There are other canons. I mean, if you go through Justice Scalia's book, she means the book with Brian Garner, Reading Law, you'll find a wealth of canons of this kind, these sorts of substantive canons. How do we reconcile our views of all these different kinds of canons? Maybe we should just toss them all out, you know? Right? Justice Kagan is a textualist, and she recognized that the growth of these substantive canons was hard to reconcile with any of the conventional teachings about textualism and court's role in interpreting the text. And of course, Justice Kagan's colleague, Justice Amy Coney Barrett, had written about the problem as a professor more than a decade earlier, writing that substantive canons are in significant tension with textualism, insofar as their application requires a judge to adopt something other than the most textually plausible meaning of a statute. Textualists cannot justify the application of substantive canons on the grounds they represent what Congress would have wanted, because the foundation of modern textualism is its insistence that congressional intent is unknowable. And while textualists do not believe that language should be pushed for any meaning it can bear, many substantive canons require judges to do just that. At the end of a long article in which she tries to justify some of the substantive canons as best she can, Professor Barrett, comes away saying, well, when a substantive canon promotes constitutional values, it might be okay, because the judicial power to safeguard the Constitution can be understood to qualify the duty that otherwise flows from the principle of legislative supremacy. So it operates sort of as a form of judicial review in a less textualist guise. Even so, even then, she says, the obligation of faithful agency is modified, not overcome. A court cannot advance even a constitutional value at the expense of a statute's plain language. The proposed interpretation must be plausible. And moreover, as she goes on to say, the rationale of many of these substantive canons is not at all clear. And then, of course, there's Justice Scalia, who was more in the Kagan camp than the Barrett camp, I think we can say. So as he put it, whether these dice-loading rules are bad or good, there is also the question of where the courts get the authority to impose them. Can we really just decree that we will interpret the laws that Congress passes to mean less or more than what they fairly say? I doubt it. The rule of lenity, he concedes, is almost as old as the common law itself, so I suppose that it is validated by sheer antiquity, but the others I am more doubtful about. Now, these are not just theoretical questions, and these are not just minor questions. As Justice Kagan alluded to a second ago, last term in West Virginia versus EPA, the Supreme Court announced the arrival of the major questions doctrine, a new substantive canon that holds that where a statute at issue confers authority upon an administrative agency, the inquiry into the scope of that authority must be shaped, at least in some measure, by the nature of the question presented. And in particular, that there are extraordinary cases in which the history and the breadth of the authority that the agency has asserted and the economic and political significance of that assertion provide a reason to hesitate before concluding that Congress meant to confer such authority. Is this textualism? Critics on both the right and the left have argued that it is not. Arguments I'm sure many people in this room are familiar with, and I won't go into detail about now, but you can sort of imagine the threads they're picking up on. A few brave souls have tried to defend the major questions doctrine, some by arguing that it is consistent with some linguistic principle of statutory interpretation, such as the ordinary rule advanced by Professor Dorfler, that we need more evidence for certain propositions when the stakes are higher. And some folks, like Justice Gorsuch, have argued that, yes, this is a clear statement rule. It's just another example of a constitutionally inspired clear statement rule. But that just takes us back to where Justice Kagan started, with the question of where courts get the authority to introduce these clear statement rules that neither state propositions in the Constitution nor reflect the best interpretation of the text. Now, it's not a coincidence that textualists have been debating the role of substantive canons, and they are right to do so. But the right way to think about these canons requires us to step beyond textualism. I'll say it again. Our system relies on not just textualism, but unwritten law. So we need to supplement textualism with the unwritten law that governs both interpretation and background principles against which interpretation takes place. As I've written and worked with Professor Steve Sachs, legal canons don't have to be recast as a form of quasi-constitutional doctrine. They don't need to outrank the statutes to which they apply, because the canons can stand on their own authority as a form of common law. Now, not every clear statement will pass this test, but this is the right test to apply to them. For instance, many of the so-called clear statement canons are really just applications of the rule against implied repeals. There is an unwritten doctrine of sovereign immunity, and the rule against implied repeals says that we don't lightly assume that a statute repeals that doctrine, just as we don't lightly assume that it repeals another statute, without enough evidence that the repeal is required by the text. The same thing is probably true of the rules against retroactivity and a number of other clear statement rules the court described. These are just applications of the canon against implied repeals to well-established doctrines of common law that apply in federal courts. Major questions, I think that one is a trickier case to justify, and I don't know that Justice Gorsuch has gotten us there. Maybe the application of this principle that high-stakes interpretation requires more evidence. Professor Alon Werman has recently built on Professor Dorfler's work and attempted to justify the major questions doctrine as this kind of linguistic principle. Maybe that starts to get us in the right direction. Although even then, we need a little more, because we need to know what the baseline is, right? Which is the extraordinary high-stakes claim? Is it the agency's claim that we have this form of authority that it's not clear that we otherwise would have? So is the baseline limited government and liberty? Or is the baseline, is the exertion of extraordinary authority the court's decision to set aside an agency action under the APA? Is it the court, in the exercise of judicial review against the executive branch, that needs to bear the higher standard of proving its conduct to be right? In which case the major questions doctrine would be backwards. In which case you would expect courts to be more deferential the more major the question is, because they need to be more sure they know what they're doing before they step into the way and take over the government from the executive branch. We need to figure out what the actual underlying legal rules are and how the APA interfaces with them, not continue to scrutinize the text of the Food and Drug Act, the Environmental Protection Statutes, or the latest ambiguous grant of agency authority to answer these questions. All of that comes from law, not necessarily the text. Now, this model of statutory interpretation I'm describing has been a part of our law for a very long time. And indeed, it was criticized more than 2 centuries ago by Jeremy Bentham, who lamented about the interpretation of statutes, that at present, such is the entanglement of these statutes with the rest of the corpus juris, that when a new statute is applied, it is next to impossible to follow it through and discern the limits of its influence. As the laws amidst which it falls are not to be distinguished from one another, there is no saying which of these laws it repeals or qualifies, nor which one it leaves untouched. It is like water poured into the sea. This, but uncritically. Bentham was right. The point of Scalia's textualism was to vindicate the law, which people were getting wrong because of their aversion to being bound by choices made in the text. But the same impulse behind textualism that shows that it's possible to get the law wrong by assuming that every choice was made deliberately in the text, or that failing to recognize that text can reflect a compromise between going this far in the purpose and no farther, That same instinct requires us to recognize that sometimes the legislature's choice was just to stop making any choices in the text either way, and leave remaining questions up to the law that came before, whatever that was, whether it was written or unwritten. Hence the need, which, again, Professor Sachs and I have tried to emphasize in earlier work, to move beyond the text sometimes, but without moving beyond the law. All right, now even these subjects are ephemeral. Important ephemera, but ephemeral. The problems with pure textualism go much deeper than this. Here is Justice Scalia's A Matter of Interpretation, a published volume centered around his lecture-turned-essay, Common Law Courts in the Civil Law System. It's now given out, like a handbook, every time a 1L suddenly discovers that he or she has an interview with a federal judge and needs to be able to talk intelligently about originalist and textualist interpretation. I see you nodding. It is a great book, but it has an important blind spot. Justice Scalia advances his powerful argument for textualism in this book based on its favorable contrast with the judge-made common law. In Scalia's telling, common law and unwritten law are judge-made law for judges to make up however they wanted to. Here is Scalia again. You must understand that the common law is not really common law, except insofar as judges can be regarded as common. That is to say, it's not customary law or a reflection of the people's practices. It's law developed by the judges. Perhaps in its very infancy of Anglo-Saxon law, it could have been thought that the courts were mere expositors of generally accepted social practices. But from an early time, as early as the yearbooks, any equivalence between custom and common law has ceased to exist, except in the sense that the doctrine of stare decisis rendered prior judicial decisions custom. Describing the 1L experience with common law cases, arguing about which rule is more efficient and which one will lead to better consequences and what will happen if you apply ex ante versus ex post reasoning to this kind of rule, he says, what intellectual fun all of this is. It explains why first-year law school is so exhilarating, because it consists of playing common law judge, which in turn consists of playing king, devising out of the brilliance of one's own mind those laws that ought to govern mankind. How exciting, and no wonder so many law students, having drunk at this intoxicating well, aspire for the rest of their lives to be judges. Now, according to Scalia, textualism was the way to escape this, to escape the attitude of the common law judge, the mindset that asks, what is the most desirable resolution of this case, and how can any impediments to that achievement of that result be evaded? But here's the problem. Maybe this is how some common law courts, or at least some common law judges, function today, maybe even a lot of them. But it is not how they were supposed to function, and it is not how they used to function. Once again, the attitude Justice Scalia describes here was held by Jeremy Bentham, who complained about it, who did not think it was a good thing. But it was not held by the founders or important historical interpreters. And students who today are raised only on a diet of textualism or its antidotes, purposivism and policymaking, lack the tools to grapple with the more foundational part of our legal system. How are judges to decide cases in cases that are not governed by statute? This art has been lost. Textualism has helped it become lost, and we need to help recover it. Just a few more examples about the urgency of this. First, consider Erie Railroad versus Tompkins, staple of the first-year curriculum. Erie, of course, held that, except in matters governed by the federal Constitution or by acts of Congress, the law to be applied in any case is the law of the state, and whether the law of the state shall be declared by its legislature in a statute or by its highest court in a decision is not a matter of federal concern. State court decisions about the law should be treated exactly the same way as statutes enacted by legislatures about the law. Courts and legislatures both make law, and the federal courts don't care which one it is. It goes on to say there's no federal general common law, courts can't participate in this, and so on and so forth. The problem is, why does Erie assume that state courts make law? Who gave state courts the power to make law? Not their state constitutions, which give legislative power to state legislatures and judicial power to state courts. Not history and tradition, which have been thought, again, to obey the separation of powers and generally leave to state legislatures the power to make law, not state courts. Instead, Erie says, this is just a fact about jurisprudence that's recently been recognized by Justice Holmes, that it's impossible to have courts deciding common law cases without having them be legislatures or make law. But it's not impossible. We saw it done for a large period of history until we started to forget about it, and until Erie helped us start to forget about it. The deeper problem here is that we have forgotten that there is any other possible way to do common law than the method invented by the legal realists and then brought to fruition by law and economics scholars. Justice Scalia forgot, in the rare occasions he did get a federal common law case, such as the infamous military contracting case of Boyle, where he decides to manufacture his own tort law rule with little basis in law. I'm sure he was thinking of the same lessons he'd written about in a matter of interpretation. This was his rare chance as a federal judge to play king. So why not be a benevolent king establishing an immunity rule that he thought was a good idea? So what Erie says about federal courts and lawmaking and state courts now recurs in state courts on their own. So maybe today, states are allowed, maybe it is permitted by the Due Process Clause and the Republican Form of Government Clause to confer lawmaking power on adjudicatory bodies called courts who make that law retroactively, then apply it to the parties before them. Maybe. But today, everybody just assumes that that's the system that they have, without any systematic attempt to show that's the system that's actually been enacted, or that that is the way it should work. From Cardozo to Traynor to I teach a decision by the New Mexico Supreme Court where they decide to become the first court ever to abolish the spousal privilege, and then were sufficiently embarrassed by it that they put it back a year later. We need better tools, and we need to move beyond textualism to understand the role that courts have in these kinds of cases. Or to go more broadly, consider natural law. I know that may be a dangerous invitation in this building, but the role of natural law principles in positive legal adjudication is one of the oldest legal debates in the Republic. They were a backdrop of our legal tradition for a long time, even when they are not enacted into law in American courts, and we need to know what to make of that. I'm not going to solve the entire problem here, but I am going to say that if textualism has no way to grapple with those problems at all, then it is missing something important. Indeed, to some, natural law is so foundational that textualism's inability to deal with it might be cause for discarding textualism entirely. But in our tradition, natural law principles, to the extent they functioned as positive law, functioned once again through unwritten law, as principles of construction of state constitutions or the federal constitution. You can go back to the foundational debate between Justice Chase and Justice Iredell about how to understand these principles and whether they provide a clear statement rule, a canon of interpretation, if you will, for reading the text of the constitutional law. But to think clearly about these problems, to make use of the insights behind textualism, we must in fact move slightly beyond textualism itself. In the current regime, courts assume that when the statutes really run out, there must be nothing to do but some kind of judge-made law. Maybe it is somewhat restrained Burkean judge-made law. Maybe it's more aggressive judge-made law. But those are not the choices that lawyers thought about when our constitutional system was created or when it grew to maturity in the 19th century. They had a view that law could be, that law was supposed to be found, not made. It might be found in custom, it might be found in first principles that were customary only in some baser sense, but it involved the same underlying jurisprudential insight behind textualism. The judge is supposed to enforce rules that have been made someplace else, not to make the rules herself or to imagine decisions that were never actually made by anybody. Justice Scalia begins common law courts in the civil law system by lamenting the current neglected state of the science of construing legal texts and offering a few suggestions for their improvement. Today, that same neglect is true of the science of expounding the common law, and the same suggestions for improvement are very much needed. Now, I will say, I am open to the critique that these old ways of thinking are dead. An unfortunate casualty of the success of Erie and legal realism and destroying the legal culture that made it possible to talk about general law principles. That's a different critique from what Erie said and a different defense from the kind of unthinking acceptance we see of it today. I'm open to that possibility. But I'm not sure that things are quite as bad as all that. I'm not sure that the old ways of legal culture are entirely destroyed. And even if they were, wouldn't it be our obligation to try to help bring them back? All right. Once we unlock the secrets behind textualism, even the text of the Constitution as well becomes more comprehensible to us. So consider just briefly Section 1 of the 14th Amendment, perhaps the most important single clause in modern constitutional litigation. And in particular, consider the Privileges or Immunities Clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. In 1873, the Supreme Court told us that this provision was basically meaningless, and many decades later, Justice Scalia urged us not to look too closely behind the hood. In oral arguments in McDonald versus City of Chicago, he famously mocked the advocate for suggesting that the court might want to look at that part of the Constitution that actually was supposed to guarantee individual rights. Why are you asking us to overrule 150, 140 years of prior law when you can reach your result under substantive process? I mean, unless you're bucking for a place on some law school faculty. The advocate insisted, of course not. Of course they would never do that. The answer, Justice Scalia's reticence comes in part from a long-standing mystery about what on earth the Constitution could be talking about here, especially in light of the fact that proponents of the Privileges and Immunities Clause simultaneously, in the space of a few pages, could say things like, this is not granting any new rights, these are only the rights everybody already has under the American system, and also it's critically important that we enact this clause because otherwise freed blacks and other people won't have rights in the southern states. How could it be that this clause is simultaneously revolutionary and yet redundant? The answer, I argue, in a new article with Judd Campbell and Stephen Sachs, an article some of you on the faculty may have seen last week, lies once again in unwritten law. The 14th Amendment Privileges and Immunities Clause is referring to the body of unwritten general law that was familiar to the amendment's drafters, even if many of us have forgotten about it in the post-Erie world. General law, the unwritten law that in the 19th century was taken to be common throughout the nation, rather than produced by any particular state, was legal orthodoxy when the 14th Amendment was written. And in the eyes of the Republicans who created the 14th Amendment, general law supplied the rights secured in Section 1. That is why the 14th Amendment was not thought to confer new rights of citizenship. It secured the pre-existing rights that were already thought to circumscribe state power, but by shifting their enforcement to federal courts and to Congress from state courts and legislatures. This kind of approach to the 14th Amendment would help us figure out the unenumerated rights that the 14th Amendment really is supposed to protect, without necessarily opening Pandora's box to judges being able to decide to include any unenumerated rights they want. This is the approach we need more of. All right, I'm almost done. Now look, before I gave this lecture, the dean confessed to me that he was very nervous about it. And frankly, I am too. I am sure that this lecture could be, probably will be, misunderstood and miscited and misquoted by people who did not hear or read it and who missed the basic point I'm trying to make here. I won't give them any ideas, but you can probably imagine. So let me try to state one more time before we finish. Textualism, to a first approximation, is central to the rule of law. But to a second approximation, we sometimes need to use other legal rules, like unwritten law, and doing so is completely consistent with the reasons that we use legal texts. We need unwritten law as a backdrop against which to read legal texts. We need unwritten law to understand the common law system, the real common law system, not the system of judge-made law that has usurped it. And we need unwritten law because our legal texts sometimes point us toward it, and we need to know how to accept the invitation. Admitting these things has risks, but denying these things has risks too. Denying them risks sending us in statutory interpretation circles, unable to explain how we can avoid being literalists and also avoid being opportunists. Denying them risks leading people to abandon textualism, and indeed positivism and formalism and the rule of law itself, because they mistakenly think that we have no other way to make sense of the central legal traditions, including natural law. And it risks leading us to close our eyes to the meaning of the constitutional text itself, because sometimes the text requires us to engage with unwritten law, to go beyond the text. If we do not teach our students how to do these things, if we do not revive the more fundamental pre-realist tenets of our legal tradition, then our students will be misled into thinking that the only choices are the plain text and judicial policymaking. That is not true, and I will take my chances in saying so. Thank you. I'm allowed to answer one question.
So one sort of contested advantage of textualism over perpetualism is its focus on notice as a due process value. The ordinary person who can read kind of fiction, can read a statute text is what the law is, I can understand what my obligations are. Can you speak to the extent that kind of original law textualism, kind of changes that?
Yeah, so this is true. This is an advantage of textualism. A contingent advantage of textualism is that it's often good at providing fair notice. I don't know if that's the reason we have textualism. You can have fair notice of a lot of very simple and sometimes unfair systems, but you can have fair notice. But, as part of the examples show, textualism sometimes fails to succeed at its fair notice goals without more. It's just the case that the statutes don't always answer all the questions we have, and so we need to do something more. And so fair notice itself can't be the answer. Now, I think this might also be a clue to how we should do unwritten law well. The unwritten law principles that were extant in our republic were also ones that satisfied principles of fair notice. There were the kinds of unwritten principles so fundamental that everybody knew what they were, and so they kind of went without saying. And if our unwritten law stops looking like that, or if our law schools stop teaching people about unwritten law in that way, then we might indeed have a fair notice problem. But the problem might be reform of the law and reform of education, rather than looking for our keys under the lamppost. Thank you.